Hello everyone, good morning. I'm Ankit and you're watching the Indian Express analysis on StudyIQ IAS English channel. Now today is 12th of February and it was also a day when I felt very difficult to get up early in the evening. Give me a minute. Today was also the morning that I felt very difficult to get up. So please make sure to hit the like button as it helps us keep motivated and it helps us keep on track so that we present you this session on a daily basis. Now today, as I've already told you, is 12th of February and we'll be dealing with 6 important articles that appeared in today's newspaper. Now there were other articles also, one of which was President Trump's meeting with Narendra Modi, which is expected to happen today. So we'll be covering that tomorrow onwards as there will be more information in that regard. So let us start our today's discussion from these 6 articles. First one is that the UP government is demanding establishment of a potato research center in Agra. Why in Agra? Because Agra is a major producer of potato and this has been a long-standing demand of farmers. Now, particularly this potato research center will be developed with international cooperation and it will help Indian government assess and also develop newer varieties of potato which will be climate resilient, which will require less input. So these kind of information or articles, these are important from GS paper 3 perspective because first of all, potato is a major crop in India and therefore it is a part of agriculture syllabus, right? So that is why we are going to cover first article. The second article is on President's rule. However, we are going to discuss only what the Supreme Court judgment has said about President's rule because on Saturday, that was 9th of February if I am not wrong, we covered in detail about various procedure and implications of what happens when President rule is applied in a particular state. So we'll be discussing the history of President rule in India and also what the Supreme Court has said about it, that can government so easily implement President rule. So that is why this kind of an article is important from GS paper 2 perspective as President rule which is implemented under article 356 and article 365 of the Constitution, which is a part of polity syllabus and therefore also important from GS paper 2 perspective. Then we'll move on to Nari Adalats as these kind of redressal mechanism are expected to happen in India as it will favor resolution of disputes among women. So these are also examples of how judicial system or alternative judicial recourse can be applied to solve disputes in any society, be it India or be it abroad. So we'll be dealing with this from polity perspective. What kind of a body is this? Is there a legal sanctity to Nari Adalat? And also these kind of mechanisms are important from GS paper 2 syllabus. Now out of these 6 articles, I can safely say that 4 articles belong to polity section, which is a rarity these days in newspapers. Also, I'll be covering National Commission for Women as National Commission for Women have served notices to many people who have been accused of making obscene comments on their YouTube channel. We are not going into details of what kind of obscene comments were they because they are not important from exam syllabus. But what is important are bodies like National Commission for Women, which is a statutory body and hence it is also a part of GS paper 2 syllabus, that is from polity and governance perspective. Then the last 2 articles will be dealing in detail. The 5th article of today is about PM Modi's visit to Paris where he was the co-chair of AI summit that was organized by President of France and he made certain statements in that AI summit. Now that statement tells us what the government or what the Prime Minister thinks about AI and its impact on Indian society in general. So we'll try to understand first of all what this summit was all about, why PM Modi went there and what kind of comments did he make. Also, we'll be concluding our today's discussion with Sankari Prasad case, which was a case heard in the Supreme Court in 1951 and it changed the way the constitution can be amended. So we'll be understanding the importance of such judgments and how the judgment that was passed by Supreme Court in 1950s, is it relevant today or not, right? So these kind of syllabus also are important from polity perspective. Also we have seen in prelims or in the mains 2016, if I remember correctly, there was this question on IR Coelho case. So similarly, you can expect such questions appearing on Sankari Prasad case, right? So that is why we'll be dealing with today's article. Now, good morning Kusum, good morning Sejal, good morning Augustine, good morning Yashi. How are you, sir? I'm good, Yashi. How are you, Yashi? Sonu, good morning. Now, as usual, the notes for today's session will be available on my Telegram channel called as EATS Live. So please make sure to go to this channel, subscribe to this channel if you want to stay updated with respect to daily notes and important articles that I post there. And also, if you are unable to find the channel, here's the QR code which you can scan. Also, I am in the process of uploading many important reels which are quite informative, not just, or they're also important for exams perspective. So please make sure to watch those reels which I upload on my Instagram handle ENKTSNGH. Right. Now it is not working. Give me a minute. Yes, it is working now. Now you can scan this QR code or go and search ENKTSNGH on Instagram. It will take you directly to my Instagram channel. Yeah. Now let us move to yesterday's why isn't it working now. Now, am I audible? Yes. Now, today's note is behaving strangely. Give me a minute, I'll set it up. Now, as I was saying, we on a daily basis cover questions which are important from prelims perspective, and also many days we cover mains answer writing initiative. Now, students, what I have seen is that they face problem when they appear or they write mains answer writing, and that is why what I intend to do with my daily session is to give you a question on a daily basis, provide you with the necessary information in the session itself, and then allow you to write such answers. And if you submit it to me, I also make sure to evaluate it, which will eventually help you get better in answer writing process, right? So, I don't know why it is behaving strangely today. Yeah, as I was saying, our intention of the daily session is to provide you with the necessary information, get you acquainted with the kind of information that is prevalently asked in the UPSC exam, and also help you solve questions and write answers. Right? This habit is very important if you develop it earlier on, because it does not matter what kind of knowledge you have. How better you are at it applying that knowledge in the exam setting, that is what matters, right? Because you eventually have to clear the exam. Now, if you want to clear this exam, please make sure to watch these sessions on a daily basis. Yes, I was saying, let us try to solve yesterday's question that I gave you in the end. What is GLP-1 RAs recently seen in the news mean? Now, the answer to this question is they are actually a class of drug that are used primarily to treat type 2 diabetes. Therefore, option D here is the right answer. Now, primarily these drugs were intended to treat diabetes condition in the persons, but we have seen that these drugs, they are very effective in reducing the person's weight because they change the way the digestive process happens in our body. So that is why these kind of drugs are now very prevalent and also very popular among celebrities that have used these drugs to reduce their weight. But we also understood that there are many side effects. First of all is the temporary stomach paralysis, which if unchecked can become a permanent paralysis. That is why these drugs, in addition to being expensive, they also have several side effects. So the answer to this question is option D. Now, we'll also be solving this mains question today. Before understanding what is actually the Sankari Prasad case and what the Supreme Court of India actually said about it, then we'll understand what are its key importance amongst the basic feature of constitution. Does it introduce basic feature or not? We'll try to understand this today. Now, let us start without delay. Our first article of the day, this article actually appeared on page 7 of the Indian Express newspaper. Now, this article actually highlights that CM Yogi, who is the Chief Minister of Uttar Pradesh, he has written a letter to Union Agricultural Minister Mr. Shivraj Singh Chauhan requesting that the center establish the International Potato Centers CIP South Asian Regional Center, and where this will be established in the city of Agra. Now, earlier the land was acquired by the UP government and it was transferred to the National Horticultural Board. But since then 9 months have been passed and no action has been taken on it. So that is why CM Yogi wants to expedite this process. Now this center has been a long standing demand for local farmers. Why local farmers in Agra? Because Agra is a largest producing potato district in the country. Now that area itself, nearby districts of Agra, it is a major potato producer. So naturally local farmers who grow potato, they want to get better income and also get better varieties. So for that, International Potato Center or a South Asian regional center of it will provide necessary details, necessary research which will be used by farmers to grow better varieties of potato, right? Now let us understand what is this International Potato Center, South Asian Regional Center. Now originally the International Potato Center, it is headquartered in the city of Lima in Peru, and it was founded in 1971 as a organization which promotes research and development activities, and it focuses on potato varieties, especially normal potato, sweet potato and Andean root tubers. Now why is actually this body located in a country of Peru? Why not anywhere else? Because you have to understand the potato crop, it itself is native to the particular area of Peruvian, Bolivian Andes, which is located in South America. So it is all but natural, right, to make a headquarter of a potato center in Peru. That is why it has been set up in Peru. So please remember this fact that potato actually originated in Southern America, particularly in Peruvian, Bolivian Andes. Now the proposed center which will be established in Agra, it will be the second major international agricultural research center in India. First one was a agricultural research center set up for rice called as International Rice Research Institute, and it was set up in the Prime Minister's home constituency, that is Varanasi. So this will be the second major international agricultural research center. So if a question appears in UPSC saying this potato center will be the first research agricultural organization in India, the answer would be incorrect, because it will be the second. The Varanasi Center for Rice was the first. Now why this city, or why or what this center would do? This center, it actually will focus on developing of new varieties of potato which will be climate resilient, which will be free from pests and diseases, and they also will be suitable for processing. Because you understand, currently the potatoes that are used for making chips, especially for Lay's chips, these are developed by the company called as PepsiCo, which is the owner of Lay's. So this is a private variety of potato. So rather than making farmers dependent on a private variety of potato, the government itself wants to make kind of potatoes that can be used for processing activities, and this center will exactly help in research and development activities for such kind of potatoes. Now Agra, as I told you, is a major top producing potato area in the country, and that is why this center would not just be beneficial for potato growers nearby Agra area, but also in the potato belt cities or states of Uttar Pradesh, West Bengal as well as Bihar. Understood? So based on this information, let us now understand why is or how much does India produce the amount of potato. Now in terms of global production, India stands second number in terms of producing potato. First one is the country of China. Now potato in India is grown both in Rabi as well as Kharif season. In Rabi season, potatoes are grown in major producing states, whereas in Rabi season we are seeing they are grown in marginal states like Uttarakhand, Karnataka, Himachal Pradesh, Tamil Nadu as well as Maharashtra. So Himalayan states as well as western and southern states, this is where potatoes are grown in Kharif season, whereas all major producing states, they grow potatoes in Rabi season. Please remember that kind of information. Also in India, state-wise, the major producers of potato, first is Uttar Pradesh, as I told you already. Second is West Bengal. Third is Bihar. And these are top three producers of potato. The other major producers, these are Madhya Pradesh, Gujarat as well as Punjab. So please remember these kind of facts, as they can be asked in UPSC exam. Now, let us try to solve this question with reference to potato cultivation in India. Consider the following statement. India is the largest producer of potato in the world. Is it correct? No, it is not. It is actually China, which is the largest producer. India is second largest producer. The second statement, Punjab is the leading potato producing state in India. Again incorrect. What did I tell you? UP, followed by West Bengal, followed by Bihar, are top three producing states, whereas Punjab is a major producing state but not in top three. So second statement also incorrect. First was already incorrect, as I've told you. We have to identify correct statement. None of this is right. Therefore, option D, neither 1 nor 2 is right. Now, good morning, sir. How to make notes for monthly magazine? Please explain, sir. See, Yashi, what you need to do right now is not follow monthly magazine. You just read it. Rather than download these notes and copy paste these notes into any digital note making tool that you have. Okay, you'll be sorted. Sejal, you are right. Good morning, Sandeep. Yashi, yes, you are right. Option D is the right answer. Now, let us move to the second article. This article appeared in the explain section of the Indian Express on page 16, and it talks about precedent rule. Now, if you look at this article, until this part of the article, you will see it describes about the procedures and implication of precedent rule, and we have covered already this on our 9th February section side. So, please watch the video of 9th February where I cover precedent rule in detail. The implications and procedure of precedent rule will cover this article from this part onwards, and this because it highlights the evolution of precedent rule in India and what the Supreme Court has to say about it, right? So, please also watch the 9th February section after this session ends if you want to understand the procedure and implications of precedent rule. I'll be discussing the evolution as well as what the Supreme Court is saying about it. Now, this precedent rule appeared in the news because the Manipur Chief Minister, he resigned from office, and if new Chief Minister is not selected in the coming days, it is expected that the states will be put under precedent rule. So, there is a possibility that actually precedent rule will be implemented in an Indian state after 2021. So, 4 years have passed. There is no state currently, or there was no state in the last 4 years that has seen the precedent rule, and that is why such kind of a development becomes important from UPSC exam, because this has not been in news for the past years, and if this is in news, it is much likely that UPSC will start asking questions this year, right? Now, let us understand the evolution of precedent rule. Now, precedent rule is actually a emergency situation in the state where the government of state cannot be carried upon as per the accordance or the provisions of the Indian Constitution. Then the central government can implement precedent rule in the state. So, naturally, this is an emergency situation which cannot be used in daily course of time, because India is a federal country where central government is there and also state government are there who derive their powers directly from the Constitution. That is why if the precedent rule were to be implemented, it is an abnormal or an extraordinary condition, right? But we have seen that since 1950, when Constitution first came into force, precedent rule has been imposed for some total of 134 times. So, this was meant to be an extraordinary measure, but you can see by the virtue of sheer number of it, this is been misused by the central government, and the states which have seen most instances of imposition of precedent rule are states such as Manipur as well as Uttar Pradesh, as they have seen implementation of precedent rule 10 times each. But in terms of duration of precedent rule, it is not Manipur nor Uttar Pradesh which has seen highest time or highest duration of application of precedent rule. Rather, it was states of Jammu and Kashmir that saw or that was under precedent rule for 12 years, whereas Punjab was under the precedent rule for over 10 years. But these are explanatory because these states, they have witnessed spells of militancy and separatist activities. So, as to control these activities, states or the central government had no other option but to implement precedent rule. So, you can excuse these two states. But what about other states? Why did actually the government implement 134 times precedent rule originally, which was meant to be an extraordinary measure? So, this actually or this misuse of precedent's power is why these kind of questions were appeared in the, or these kind of disputes, they went to the Supreme Court of India. Now, you have to remember the most recent imposition of precedent rule was back in 2021, where precedent rule was imposed in the Union Territory of Puducherry when the Congress government fell in 2021. Now, Puducherry in general has spent over 7 years under precedent rule, and this is because of repeated cases of infighting and the government of that Union Territory losing the power. So, why did actually, when this has been used for 134 times since India got independent, why was last precedent rule was 4 years back and not right now? the answer to that is Supreme Court has restricted the implementation of precedent rule. So let us try to understand this. How has actually Supreme Court restricted the implementation of precedence rule? Now Supreme Court, it heard the matter of whether application of precedence rule was just and necessary under the case called as SR Bommai versus Union of India case, the judgment of which was passed in 1994. Now this matter actually came towards Supreme Court because there were several instances where the central government, it imposed precedence rule and dismissed the state governments. Earlier, when Prime Minister Nehru or even Prime Minister Indira Gandhi and Morarji Desai was in power, there was this trend that whenever a new party came into power in central government, they dismissed all the state governments under precedent rule. So this was the sheer audacity based on which the central government dismissed the state governments. So actually this matter reached Supreme Court, and Supreme Court in this SR Bommai and Union of India case, it gave several judgments or it gave several directions. So let us try to understand this. Now this judgment was passed by a 9-judge constitutional bench, and all of these 9 judges, they agreed on one fact, that President's power to issue the proclamation of Precedence Rule under Article 356 was actually a subject of judicial review, that actually this or the High Courts or the Supreme Court, they actually can review the decision of President when he or she implements the Precedence Rule. Now the court, it could examine whether the decision of President was actually illegal, malafide, or was made under extraneous consideration, or was it an abuse of power or fraud. So in these cases, if the court finds out that this judgment was illegal, malafide, or was a matter of fraud, the court can actually struck down the imposition of precedent rule. However, the Supreme Court, it also acknowledged that it cannot wait or it cannot judge the correctness of President's action. However, what Supreme Court can do, that it can seek what the material did the President consider before making such decision. And if this material was relevant, then the Precedence Rule is justified. But what if this material was not relevant? Then the Supreme Court can actually struck down the Precedence Rule. So this was the case that Supreme Court highlighted, that in certain cases, or that in all cases it has the power to judicial review, and if it finds out that the decision made by the President was not just or was a matter of fraud, then it can struck down the Precedence Rule, right? Now, while doing this judgment, the Supreme Court also gave certain suggestions, or it imposed certain guidelines. First, if the Precedent Rule is implemented in the state, and after this valid proclamation, until the time it is approved by the Parliament of India, the Supreme Court or the Union government cannot dismiss or cannot dissolve the assembly of the state. Rather, what it can do is that it can only keep the assembly in the suspended animation, and only after this proclamation is approved by the Parliament of the House, then only can the assembly be dismissed. Also, without the approval of the Parliament, if the central government is unable to dissolve the House, then what the Supreme Court will do is that it will reinstate the state government. So this is what the guideline is, that until or unless the Parliament does not approve the implementation of Precedent Rule, the central government cannot dissolve the state assembly, and it has to keep it in suspended animation. And what if this government is unable to get the permission of the Parliament to impose Precedent Rule? Then the Supreme Court will restore the state government, right? Now, one of the judges also highlighted the fact that under the scheme of constitution, the constitution provides larger power to the central government as compared to state government. But this larger power to the central government with respect to state government, it does not give the central government the right, or it does not make state governments the appendages or the smaller power than the union government, right? And also, after this judgment, we have seen that the Supreme Court's decision in this judgment has actually made central government afraid of imposing Precedent Rule, and we have seen the cases of Precedent Rule, it declined after the SR Bommai case, right? So this is what the article talks about what the Supreme Court has to say about Precedent Rule, and also the evolution of Precedent Rule and the number of cases where the Supreme Court has actually nullified the Precedent Rule, right? Now let us solve this practice question. This practice question also is a PYQ which appeared in the prelims of 2017. Now which of the following are not necessarily the consequences of proclamation of president's rule in the state? So out of these three scenarios, we have to identify what does not necessarily happen after the implementation of president rule. Now dissolution of state legislative assembly. What did I tell you? That after the president rule is proclaimed, the president, it suspends or it keeps the state assembly into the suspended animation, and only after it is approved by the parliament, then only it is dissolved. So dissolved is actually cancelling of the session, suspended is actually just prorogation of the session, right? So dissolution is not a necessary condition, rather it is one of the two conditions which can happen after implementation of the president rule. So first is incorrect. Removal of the Council of Ministers of the state, yes, it is right. As soon as president's rule is applied into the any state, the power of that state government is not given to the state government or the chief minister, rather it is bestowed in the governor of the state who governs that particular state as per the aid and advice of the president of India, right? So removal of council of ministers, yes, it is a necessarily measure which happens after imposition of president rule. Now dissolution of local bodies. Why will local bodies be dissolved if the matter is related to state government, right? This is the third tier of governance. So third is also incorrect. As only second is right, first and third was incorrect, and we have to identify not necessarily, which means incorrect options. Therefore, first and third, option B here is the right answer to this PYQ. Now, as I tell you every day, right now we are offering this Sampoorn batch, which is meant as a foundation batch for every student who are preparing for UPSC syllabus. But why am I discussing this right now? Because right now we are offering discounted courses for even for Sampoorn batch, and after 14th of February the prices is expected to increase. So let me tell you how to register for this courses. For example, you go to a StudyIQ website, you create an account here, and after logging into account, you click on explore courses. Now, if you click on explore courses, there are many courses that are available. For example, this is 2026 Sampoorn batch, whereas there is also a 2027 batch, which is specially for the students who want to give their attempt in 2027, right? Suppose if you are want to give attempt in 2026, so this batch is for you. Click on this batch. Right now, you'll be able to see that this is available at 36,249 rupees. But I have a way when you can get discount even on this amount. For example, there must be a ticker flashing on the bottom half of your screen that says the code ATS Live. So you have to use that in order to buy this course. For example, this is available at 36,249 as I tell you. And if you click on promo code here, there is an option to enter the coupon code and write here ATS Live and apply it. Now, if you see from 36,249, the course money, it is reduced to 28,999. So, please click on the buy now after applying the code ATS Live, and please save the hard earned money of your parents and yourself, right? Now, moving back to our discussion. Let us go to another article. This article actually appeared on the page 8th of the Indian Express, and it states that the union government, it has actually written to states in order to invite the proposals for establishing Nari Adalat. Now, Nari, the word in Hindi, in English, if you translate it, it means women. So, this is actually a women's court, right? Now, actually the government is running these Nari Adalats in 50 gram panchayats each of states of Union Territory of Jammu and Kashmir as well as state of Assam, and they began on a pilot basis back in 2023. Now, after this success, the government is trying to replicate these kind of courts in other states also. Now, in 2024, the Women and Child Ministry released over 20 lakh amount each to these states so as to implement this scheme, which is called as Nari Adalat. So, let us try to understand what is this Nari Adalat all about, or how it is different from existing courts in the country. Now, this Nari Adalat scheme, it is actually a scheme by the Ministry of Women and Child Development, and it entails a group of women at each panchayat level who will resolve grievances among women and also the women who were denied their rights. So their matter will be heard by the Nari Adalat. Now this Nari Adalat scheme, it is a part of Sambal sub-scheme of Mission Shakti. This Mission Shakti is a scheme which dedicates or presents an effort to strengthen the women's rights, safety, security as well as provide them with necessary empowerment. Now the members of these Nari Adalat will be called as Nyay Sakhi. Nyay in Hindi means justice, whereas Sakhi in Hindi means friend. So technically these are friends who will provide you with justice. Now, the Nari Adalat in each village, it will consist of members between 7 to 11 in number, and half of these members, they will be the elected members of the Gram Panchayat, whereas rest half will be the women with social standing like teachers, doctors, social workers who will be nominated eventually by the villagers. Now, the head of Nari Adalat will be called as Mukhya Nyay Sakhi, that is the chief justice friend, and also they will be chosen among the existing Nyay Sakhis only, generally for a 6-month term. Now, the Nari Adalat, you have to understand in terms of legality, it does not hold any legal status. That means its judgment will not be legally binding on the person. Rather, what this Adalats will look to do is to reconciliate or to get people together and help them resolve their differences. And also this is a very constructive way of resolving the differences, because eventually the intention of you is to make them friends and not enemies, right? So this looks at a long-term resolution of disputes and the grievances, right? Now let us try to solve another practice question with reference to Nari Adalats in India. Consider the following statement. These are primarily aimed to provide legal aid and mediation services to women facing domestic violence and social injustice. Yes, it is right. These courts operate as a part of National Legal Services Authority's initiative to promote gender justice. This is incorrect. Why? This is a part of Ministry of Women and Child Development and not National Legal Services Authority. So second is incorrect, first is right. Therefore, option A here is the right answer. Now moving to another article. This article actually talks about that National Commission for Women. They have summoned YouTubers like Ranveer Alabadia and Samay Raina. Now they made some obscene comments on YouTube, and necessarily that is why the National Commission for Women, as these comments were made against women, they have summoned them. Now this kind of a controversy is not important for exam. As I have told you already, what is important is actually what is this National Commission for Women. So let us try to understand about this National Commission for Women. It is actually an autonomous and a statutory body that was established in 1992. And why it is a statutory body? Because it was established as per a law passed by the Parliament. A law is also known as a statute, right? So this law was called National Commission for Women's Act 1990, which was intended to promote and protect the women's rights in India. Also, this body is responsible for reviewing and addressing issues relating to rights of women and making recommendations for protection and promotion of women's rights to the government, right? So this is what this body does. Now the composition of this body is actually, it consists of a chairperson, 5 members, and among these 5 members, one at least should be the member from scheduled caste or scheduled tribe, and a member secretary, and the appointment and removal of all these members are under the powers of central government. Now the tenure on which they serve as the member and the chairperson of NCW is that both chairperson and every member shall hold office for a period of 3 years, right? Now, the powers of National Commission for Women, it is given under section 100 of the NCW Act, and it gives this commission the power of suo motu cognizance, that it can consider cases on its own, not necessarily when it is referred to them from any women or so, right? So this is what suo motu cognizance is. Suo motu in legal terms, it means on their own. Now, they can consider the case on their own, first of all, when there is violation or deprivation of rights of women, or if there is a non-implementation of any law which was enacted originally to protect and promote the rights of women. Also, if there is no compliance for the policy decisions, guidelines or instructions passed by any legal body, then also the National Commission for Women can reconsider or take the matter in their own hands. Also, this suo motu cognizance can also be taken on basis of print, electronic and social media report. So we understand this matter was referred to NCW based on this only media reports, right? Now let us try to solve another practice question. Nari Adalat decision is not bounded, so at what level it will be effective? Like when you see Sejal, right, especially when there are elders in the house and if two brothers are fighting, so what do elders do? They bring both these two fighting individuals and they make them sit and tell them resolve their differences, or otherwise I'll stop your food. So that is why under the external pressure or by the authority of the senior, the juniors or the individuals, they resolve their dispute and eventually shake hands, right? So this is the process what the Nari Adalats is looking to do, that instead of making them a court case or a legal binding judgment, they are just trying to better the relationship between two fighting individuals. What if a man and a woman, they are engaged in a legal or in a household dispute, right? So that dispute, instead of going to court, can also be solved by presence of elders or gaon ke bade, right? So this is what is happening in the Nari Adalat. So even without the legal sanctity, they are quite effective in getting their disputes resolved. Now let us solve the practice question. Consider the following statements regarding National Commission for Women. The National Commission for Women is a constitutional body to safeguard the rights of women. No, it is not a constitutional body, as there is no constitutional provision which provides for NCW. Rather, it is a statutory body, because this body was made as per the Act of Indian Parliament. Now this commission, it consists of members appointed by the central government after consulting the states. This is also incorrect. The central government appoints these members on their own and it does not need to consult the states. So second also incorrect, first is incorrect, therefore option D is your right answer. Now let us move to another article. This article appeared on the very first page of the Indian Express newspaper, and it talks about that PM Modi is on his visit to Paris, where he was the co-chair of the AI summit. So he made certain statements in this summit which will become important as far as governance of AI in India is concerned. Now PM Modi, in his speech in the AI summit, he called for global collaboration to harness the potential of artificial intelligence so as to promote economic growth, undertake technological transformation and also undertake sustainable development. Now he also emphasized that there is a need to build quality data sets that are free from any biases and also embrace an open source model. What is an open source model? Suppose any company develops an app, and if it provides that app for free to any individual and also makes the code that is used to make that app available for everyone, that is called as open source. For example, Android, which is an operating system by Google, it is an open source platform, and so is the UPI. That UPI allows the app makers to modify it UPI, right? So these are examples of open source software. Now he also said that, or he rather gave a very hopeful message that actually the AI, it will not reduce the amount of jobs, rather it will only help people in doing their day-to-day jobs, right? So this is what he has said. We'll look into it detail after our today's discussion. Now, why was this summit happening? There must be some intention, right? So this actually summit which held in the city of Paris, it was actually a built upon summit which earlier happened in a city of UK as well as in Seoul, which is the capital of South Korea. So this was the third global summit on AI. Now this summit particularly, that is Paris summit, it focused on 5 different areas. First of all is that using AI for societal benefits, that is using AI for public interest. Second one is to actually address what the AI or how the AI will impact on jobs. Will it reduce it or will it help people in doing their day-to-day jobs? Also, the countries that got together in this summit, they decided upon how to encourage AI in order to drive the technological innovations in their country. Also, these AI, they are made by large data sets, and these programs are usually closed for outer public to see, and that is why we need to enhance the transparency and accountability, that what if I make an AI, will I be accountable to the public in general, and what is the process of making these AI, are these AI using biased data sets or not? So this is why we need to encourage trust in AI, so that whatever AI program we make, it is actually free from biases and is providing you with the actually factually correct information. Further, there is a global attempt in order to govern and regulate AI, and these are done by various different bodies such as Global Partnership on AI, G7, G20, but you understand these bodies do not consist of every country on the world. So you need a global platform like such AI summits that invites each and every country to participate in these summits and decide upon how and whether to regulate AI or not, right? So this was the intention of this summit. Now, what was actually India doing is this summit? You have to understand India now is also a major player in AI, if not as big a player like United States or China. Now, Indian government recently brought an India AI mission, which is a mission of budget more than 10,000 crore, and this mission intends to procure GPUs which are used in AI and use these GPUs to give it to startups and Indian companies so that they can undertake their AI research. Also, India is a part of global partnership on AI, that is GPAI leadership, and India as a lead chair of this organization, it aims to make itself as a global AI governance hub. So earlier we have seen that in many transformative technologies, India was outside the regulation discussion, but now India has changed. It is trying to become a globally recognized power, and that is why India's participation in such governance efforts is necessary, which is provided under the GPAI. Also, India wants to bridge the gap of AI divide, ensuring that AI and its benefits are available to all the countries, not just developed countries. And also, India represents the interest of Global South, which is a coalition of developing countries. So, India would want any development in AI not to exclude the developing countries, and that is why India was present in that summit. Also, you have to understand that India prioritizes the development of Global South. For example, India itself has made a transformative digital payment system known as UPI, which it has given to many other countries. Similarly, what if India tries to make AI? Similarly, it should extend these benefits to other countries, which will help developing countries preserve their resources and undertake development efforts. So that is why India was advocating the interest of Global South priorities. Also, India wants these AI governance to be inclusive, that is both developing and well as developed nations should participate in developing newer standards, and it should focus on ethical measures, transparency as well as accessibility. So this was India's intention into the AI summit, that not just the global powers like US and China, they will decide on what or how AI should be governed, rather even developing countries, primarily India, should also decide. So India was having a stakes in the AI summit, right? Now let us understand what the PM Modi highlighted in his speech. First of all, he said that any AI platform, first of all, should be open source, that is its source code and as well as its data set, it should be available to all and not just on a paid basis like what OpenAI is today. Also, the data which is used to train the AI should be free from biases, that it should not cater to any political, religious or social ideology, rather it should provide with the factual information. Then only you can understand now the AI will provide you with the necessary and correct information. What if AI is trained on a basis of on a very biased basis? So even the information which will eventually be provided by AI will be biased. That is why we need data which is both open source and free from biases. Also, these AI are making AI tools, they are quite energy intensive in nature, that you need to give a lot of power to them. Now, generally you can understand the power which is used to train AI, it is sourced from polluting sources like thermal energy. So there was this need to make these power processes and training of AI processes more sustainable in nature. So for that, we need cleaner sources of energy like renewable energy, nuclear energy, and also not just energy, but overall this program should be sustainable in size, data needs and resource requirement. So it talks about overall sustainability. It should be efficient in terms of data and it should be efficient in terms of power consumption also. And in addition to providing them with the power, you should use cleaner sources of energy, particularly nuclear energy and renewable energy, to power these AI tools. Also, PM Modi highlighted that he was quite optimistic on the job prospects after the AI is in application. Now, there is this conventional wisdom that AI will replace menial jobs like day-to-day jobs, call center operations, they will be replaced by AI. But PM Modi has highlighted that although it will eliminate low-skilled jobs, but it will provide much more jobs in the medium and high-skilled sector. And that is why we need to make people skilled enough so as to they are aware of AI tools and they seek jobs based on AI, right? So this is what PM Modi has highlighted, that the focus should not be on whether the jobs will be removed, but rather the focuses of nation should be on skilling of its workforce so that they are able to get jobs in the AI sector, right? Good morning, Bishwabrata. You joined the session late, no problem, you can watch the video if you have left out. Now let us move to the last article of the day. This article actually appeared on page 14 of the Indian Express, and this talks about a case the judgment of which was given by Supreme Court back in 1951. So let us try to understand what this article talks about. It talks about an individual known as Sankari Prasad Singh Dev. Now he was actually a jamindar or a landlord in the area of Kashipur, which was back in West Bengal. Now the Supreme Court, he went to Supreme Court challenging the nation's first plank for social revolution, which was abolition of zamindari system. So actually Sankari Prasad was a zamindar and he did not wanted the abolition of zamindari system, which was implemented by the central government. Now you have to understand what was the zamindari system. Now during the British era, the land revenue system was changed, that instead of small farmers, the ownership of land was given to a particular zamindar, and that zamindar was responsible for collecting of revenue and eventually getting it to Britishers. So theoretically, after India got independent, all the lands that were under the British rule, it became, or the zamindars became the owner of it, which naturally denied the land rights to many farmers. So the intention of government was to abolish this zamindari system and distribute the surplus land among the landless farmers. Right. Now this move was actually resisted by the existing zamindar, and Sankari Prasad Singh was the first or also zamindar. Now just after constitution came into effect, government of India, or just after the India got independent, government of India implemented many measures to implement land reforms, one of which was abolition of zamindari system. And not just the central government, but many state legislatures, they also passed similar judgments and similar legislations. Now one of this Bihar State Management and Estates Tenure Act 1949, it went to the Patna High Court, and Patna High Court said that this was actually unconstitutional and void because it violated the zamindars' right to equality, because after taking the land they were not provided with necessary compensation, and also any law that actually goes against the very idea of fundamental right, it should be unconstitutional and void. This is what the Patna High Court said. Now according to this judgment, the zamindari or the existing zamindars, they won the first round. But before challenging this judgment, what the Union government did, that it undertook the first amendment to the Indian Constitution, which made many changes. For our today's discussion, two changes were important in the first amendment, that was introduction of Article 31A as well as Article 31B. Right. Now Article 31A, it states that no land acquisition law would be deemed against the fundamental right if they were to implement land acquisition measures or abolition of zamindari system. So in one swoop, the zamindars, they could not claim that any of the fundamental rights were violated just because the government of India implemented land reforms. So this was Article 31A. Now Article 31B, it brought into action what was known as 9th schedule. Now if any law is placed into the 9th schedule, it means that it cannot be challenged into the court of law. So this actually prevented any laws which were passed by Indian Parliament, and if it were placed in 9th schedule, to be challenged into courts. So these were the two changes that were brought by the first amendment, which is relevant from our today's discussion. Now Sankari Prasad Singh, when he went to Supreme Court, he argued on the wider implications of first article or the first amendment. He said, first of all, as it was a provisional parliament, so it did not have the competence to amend the constitution. And even if the provisional parliament had the competence to amend the constitution, it cannot violate, or any law which is passed by the parliament, it cannot violate or it cannot take away the fundamental rights of any citizen, because according to Article 13(2), any law which is passed by the parliament which takes away the fundamental right, they can be considered or they can be reviewed by the higher courts of our country, and if they actually violate the fundamental rights, they can be called as unconstitutional, which is under Article 13 subsection 2. So this is what the Sankari Prasad Singh challenged into the Supreme Court of India. But Supreme Court of India, it gave its judgment on October 1951 and stated, which was a judgment given by 5 judges in total, it stated that there is a clear demarcation between ordinary law which is passed by the parliament in its legislative power and a constitutional amendment which is passed by parliament as a part of its constituent power. So if any ordinary law takes away the fundamental right, it can be unconstitutional. But if there is a constitutional amendment, if it takes away the fundamental right, that is actually legal and not unconstitutional. So according to Supreme Court, as per the Sankari Prasad judgment, the parliament, it cannot make a statutory law to violate fundamental right. However, there is no such restrictions whenever there is an amendment of the constitution. So, theoretically, according to Sankari Prasad case, the parliament, by the virtue of its constitutional amendment powers, it can take away the fundamental rights of citizens, right? So, the judgment, it highlighted that the fundamental rights of Indian citizens, they were not inalienable and they can be taken away or they can be amended by the process of constitutional amendment. However, this cases eventually went again to the Supreme Court, and in a series of judgment, particularly in the Keshwanand Bharti ruling, the Supreme Court highlighted that actually there are some part of the constitution which is called as basic structure, and any parliament cannot take away that basic structure or it cannot remove that basic structure out of the Indian constitution, right? So, technically, it said that fundamental right was a part of basic structure, so no constitutional amendment can actually exclude fundamental rights. However, the right to property, it said it was not a part of basic structure, so it cannot be taken, or it can be taken away by the virtue of constitutional amendment. So, the current position of Indian constitution, or whether or not parliament can amend fundamental right, is that it cannot amend fundamental rights, especially those fundamental rights which are the part of basic structure of the constitution. Understood? So, this is what the judgment was all about. First of all, it heard a matter relating to a zamindar, or whether or not their land can be procured with, or whether or not the parliament can violate their fundamental right by passage of such laws, and it said, or it divided the powers of Supreme Court or the Parliament of India into two different sections. First was a normal legislative power, which did not give parliament the right to take away the fundamental right, and second was the constituent power, which actually gave the inalienable right to Parliament of India to make any changes in the constitution, right? Now, let us try to solve this practice question which I have curated on a 2016 question based on IR Coelho case. Now, what was held in the Sankari Prasad case? In this context, can you say that fundamental right is of key importance amongst the judgment of basic structure of the constitution? Now, naturally, you will start your answer with an introduction and you will highlight that Sankari Prasad case, it went to Supreme Court as the zamindar. He highlighted that that the parliament, it took away his fundamental right. So, this is how you will introduce your answer. Now, what will be the body of your answer? First, your body will highlight the Sankari Prasad judgment, that it said there are two powers of the parliament. First is a legislative power and another one is a constituent power. Another legislative power, it cannot take away fundamental right. However, under constitution power, it can amend the constitution and take away fundamental right. So, this is what the Sankari Prasad judgment says. Now, the second part of the answer, you will actually highlight whether or not fundamental right is the basic feature of the constitution. Here, you will write Keshwananda Bharti case. That you will say that in 1973, Supreme Court of India passed the judgment in Keshwananda Bharti case, which said that the parliament cannot take the or cannot change the basic structure of the constitution, right? And this basic structure, it included fundamental right in it, where it did not include right to property in it, right? So, technically, Parliament of India cannot remove fundamental right, whereas it can remove right to property. So, this is how you will write your answer. Now, conclusion of your answer, you will write that the powers of Indian Parliament, whether or not it can change important provisions of the constitution, right now are determined by the judgment of the Keshwananda Bharti case, and since then we have seen that the Supreme Court in many judgments have added upon what constitutes the basic structure of the constitution, right? So, this is how you will conclude the answer. Now, I am expecting each and everyone to attempt this answer, and I will be appreciating the creativity that you demonstrate in your answer writing. Please submit your answers in my Telegram channel. I will be more than happy to evaluate it. And before concluding today's session, this is the question for today, which is also PYQ for 2020. I will discuss it before the start of tomorrow's session. Now, if you like this video, please like or give us a thumbs up, and also please let us know in the comments how do you like this session after this video ends. So, I will be seeing you again tomorrow at 10 AM sharp. Until then, please have a very good day.